testify that that's the basis for her claim that she did not flee.
Right.
May I respond?
Yeah.
Your Honor, I have not seen what the prosecution has uncovered.
Well, they haven't seen it either.
Okay. I don't even remember honestly what texts there were. I have no memory of this. But what I will say is when I had my client on the stand and I was asking her what her intentions were, I was asking her what her plan was, and I thought her testimony was going to be, I planned to go to Novi on this day at this time. I didn't plan for her to say, my attorney told me to do this. That was the plan we had. That was what I was in touch with Miss McDonald about, but she wouldn't call me back.
Okay, I don't know why you keep telling us that.
Well, I'm just saying, I didn't mean to open the door. So I would ask, I didn't mean for my client to open the door. I would ask the jury just be instructed that whatever was discussed with the attorney be struck from the record and move forward is.
Wait a minute, struck from the record, what she already testified to?
Yeah.
That is not happening.
Okay, then I object, Your Honor. I don't think that my client opened the door to all privilege being waived. And to be honest, I don't even know what they're talking about. So until everybody sees it,
Okay, well, you want everybody to see it?
no, I don't. I'm objecting to anyone
Okay, what do you
opening
mean
it.
everybody's seeing it? Though he's specifically saying that there are potential texts between you and your client. So an investigator may have extracted this information, or presumably the prosecution has not seen it. But if it's a communication between you and your client, presumably you have seen it at one time.
I don't know that it's between me and my client. It says Shannon Marielle on there. I don't know which of the phone numbers they saved. I don't know.
Okay,
I have
don't
no
know.
text on my phone, so I don't know. I went through to look through my own phone. I don't have anything. I don't know what they're talking about. Even the screenshot he sent, I don't know where that came from.
Well, Judge, then
Do you know
obviously,
which phone it's from?
yes, it's from the defendant's burner phone. And we can tell that because of the context of the other messages on the phone.
Okay, so it's her phone. That's-
Her phone, but I don't know who, at that time, Marielle and I were both in touch with Mrs. Crumbley, and
It doesn't matter who it is.
yeah, I'm just saying, I don't know if Marielle sent texts. I don't know who the phone number is that's called Shannon Marielle.
Okay, but I guess the thing we're grappling with here is whether or not your client, obviously the privilege belongs to her. The privilege is like the theme of this trial, right? So the privilege belonged to her. So really the question is whether or not she waived the privilege. I would have to say that this would be a dangerous precedent. To be honest, Mr. Williams, when we ended the day, as we do every day with upheaval, I assumed that your concerns were the fact that she testified that she went to bed at 11 o'clock, took 4 Xanax, and then was later asked when the police came into the room, this is an exact quote, were you aware there was anything going on? No, we were not. And that would have been at 1:30 in the morning per the body cam. So I thought that's what your concerns were directed at.
So, Judge, I think the testimony was there were a swarm of officers on scene by 11:16 a.m. And then, in fact, if the
Was there? Okay.
PM, I'm sorry, PM.
Okay, we were, I'm put in a difficult position because some of these transcripts are not immediately available. But I had my staff, who's probably on the verge of resigning based on my requests of them, pull testimony of David Shaw. Did David Shaw say he was there before midnight, got the call at 11:30, was on call, was 25 minutes away, was at the building an hour and a half to 2 hours before entered where the defendant was at 1:33.
So, Judge, Mr. Kirtley testified that he called 911. That was at 10:43 p.m. That there were officers on the scene within 5 to 10 minutes. And as soon as they found the license plate, there were swarms of officers. That is what happened. I'm not sure about the other testimony.
What time was the first officer on the scene?
It was before 11.
It was someone before Mr. Shaw.
Yes.
Oh, okay, so I told the wrong officer. What's his name? Kirkley?
May I just, so Corporal Shaw was a member of the Detroit SWAT team, so he
Oh,
was
he was a
recalled.
SWAT, okay.
That's right, Judge. So he was recalled once officers were already on scene and set up a perimeter.
Okay,
The testimony that came in through Mr. Kirkley, the individual who called 911, was that he called 911 at 10:43. Then we watched the video where he walked into the building. At the end of the video, you see the two Detroit police officers pulling up on scene shortly before 11 o'clock. His testimony was that he met with them and then there were swarms and swarms of officers.
okay.
And so, Judge, it's relevant just in the fact that the defendant is texting anyone at 11:16 p.m., but it's especially relevant that she's commenting on her status and now saying, the reason I didn't give myself up was because my attorney told me not to.
Well, I already agreed with Mr. Keast last night that he would, I guess the theme is you can't use your shield as a sword. So I already agreed with Mr. Keast yesterday that he could ask the defendant, you said that you were asleep by 11 o'clock. Isn't it true that you were texting your lawyer as of 11:16? So that's already a ruling of this court. The question now is whether or not I'm going to go farther than that based on the privilege and the dangerous precedent. But
Judge, I think the case law is clear. The defendant didn't have to testify and she did not have to rely on her attorney. I also think Ms. Smith's argument that she was just going to say she was going to Novi, well, she would not have known that on her own. That was clearly information she got from her attorney. So what she wants to say is, Judge, I didn't know what to do. I was relying on my attorney. I wasn't fleeing. And the question is that in fact what she had been told, or was she doing that on her own? We'll only know that if the court reviews these messages in camera. It doesn't mean they're admissible. What it means is the court will determine if they're possibly relevant, let us see them, and then of course we'd have a discussion or a ruling on whether or not they're actually admissible.
okay, what did you say? I've seen some of the extractions, piles of extractions from here. So I guess I don't know what you'd be referring to. I don't know that I'm willing to do that. That sets a dangerous precedent.
Judge, I don't think it does to do it in camera. Privileges can be waived.
I
And this
don't
defendant
privileges
has
can be waived. It's the theme of the trial. But the problem is then I'm making a determination about what's in and what's out in the middle of the trial, right? And
No.
and potentially invading her privileged communication with her lawyer.
Judge, I'm not asking the court to make a call whether it's in or it's out. I'm asking the court to simply look at it and see if it goes to the issue of flight, then allow us to see it. And then there would obviously be an argument of whether it's relevant and admissible.
Okay, you're asking me to review it and see if it goes to the issue of flight.
Yes, Your Honor.
Okay, because that's another thing that I was thinking about. What if she makes some admissions to her lawyer about this case?
Those then, Judge, if they're just about the case, we would not be entitled to see those.
Okay. All right, what else, Ms. Smith? What else?
I have nothing further, Your Honor. My client does not waive privilege. That's the position she's taking. So whatever the court says.
The question is whether she waived it on the stand. What were her exact words?
And she said, the question was, Ms. Smith, all right, so okay, so you know you're charged, which by the way, Judge, they knew they were charged. They suspected they were being charged on December 1st. There are text messages not to their attorney on December 3rd at 11:30 a.m. saying we have been charged. So she knew she'd been charged. Ms. Smith said, so you know you're charged and you know they want you. What was your plan at that point? Well, I was in touch with my attorney, Ms. Smith, me, you, the answer is probably you. And I was taking your advice that we're going to turn ourselves in. And then further on, Ms. Smith, okay, ultimately on the night of the 3rd, were you aware on Friday afternoon if you could go into court that afternoon? What was your awareness? Defendant, I was not aware that we could go into court that afternoon. I was just waiting on direction from you.
All right, I'm going to take a brief recess.
All right. You may be seated.
Your Honor, calling people versus Jennifer Crumbley, case number 222799990 at the.
Good morning again. I want to indicate that I've done some research on this matter. I think that the privilege that the defendant holds is her absolute privilege and protects the constitutional rights. So I think this is a very serious issue, and reviewing these records could set a very dangerous precedent. However, I also note that the prosecution is requesting that the review be for a limited purpose on the issue of flight and not on the issue of anything else. How indicates that, and this is how indicates that a waiver is to be predicated not only when the conduct indicates a plain intention to abandon the privilege, but also when the conduct, though not evincing that intention, places the claimant in such a position with reference to the evidence that will be unfair and inconsistent to permit the retention of the privilege. It's not to be both a sword and a shield. And that's really what I'm grappling with. The claimant here will be the prosecutor. And I think if I didn't review these texts, that it could be potentially unfair to the claimant, that being the prosecutor on this limited issue. I can't tell you how reluctant and how much I do not want to do this, because I think that the privilege is so important. However, I've been told that this is going to be a limited review. The jury has been here since 8:30, and they've been here for 2 weeks, and I'm very conscious of that. So I am going to review the text for the purpose of determining whether or not there is reference in any way to flight.
Your Honor, the text, as you said, my client has the privilege over. I'm asking that my client and I be able to also review whatever's being submitted in camera.
Okay, well, here's the difficulty I have. If you go through my phone right now, you can find texts back to when they were cooled. It's really hard to believe that you don't have texts from 2021 between you and your client.
Your Honor, I don't. After a year, all of my texts delete it automatically. And I have it set to that because otherwise I get so many. I use my phone for personal and business. So
Okay,
they delete
what's
after a
your
year.
position on her receiving an
Well,
unredacted copy of these texts?
The other thing is, I don't know if those were even sent to my phone. It says Shannon Marielle. I don't know whose phone it went to.
Okay, here's the problem. Her testimony is, I was waiting for instructions from you.
Okay,
She
but
said
at the
you.
time, so
Judge, if I may, if they're not to counsel, then they're definitely not privileged. So that's one of the reasons. I have a screenshot, one screenshot I saw. If that's a fake for some other person, a friend, boyfriend, whatever it is, then absolutely it's not privileged.
well, at that time
If it is
Marielle
with
was
counsel,
here. I don't
It
know.
needs to be reviewed. One other issue, Judge, this is a very narrow time frame. This is after noon on December 3rd, up to the point when they're taken into custody at 1:30 a.m. on December 4th. I haven't seen these, but I know it's a total of 23 messages, and I know how thick this is. So this is a very, very limited number of messages.
What is your position on Ms. Smith receiving an unredacted copy?
I have no problem with that. I think, Judge, she probably got it in the Cellbrite reports before they were stripped out for
Oh,
us,
yeah.
but I don't know for sure. I have no problem with her getting a
So
copy. when the court-
that's a good point. Even though they extracted any privileged communication between the defendants and their counsel from these texts, you and Ms. Lehman did receive an extraction that included attorney-client communication. So I believe you are in the receipt of these and have been for 2 years.
I don't believe that's true. I've never seen these, but I don't believe that's true. I believe I received the Cellbrite data that the prosecution has been using throughout this case. I don't believe I received a copy that included my communications. I believe they were stripped out before I got them.
Because it is possible that they were stripped out before they were brought. I want to be careful that I don't misrepresent. I do know that the screenshot would have been in there because that's what we saw in our version.
Okay, so at a minimum, the screenshot
Yes.
would have been provided. Okay, to me, the screenshot is now on the table for sure.
Yeah.
Because I guess I should say that because of what happened the week before the trial, they're aware, that the prosecution is aware of that, communication. So at a minimum, the 2-word text was coming in. Okay, so I'm gonna have a copy made from Ms. Smith of these texts. You don't have any objection?
I
to that?
don't, Judge.
All right, and I'm gonna review them, and determine whether or not any of those texts are relevant on the issue of flight alone.
Thank you, Judge. May I approach your clerk?
Yes, all right. Okay, and, if you're correct that they're brief, I will be brief. The jury's waiting for us, okay?
All right. Okay. Okay, that's fine.
Can she stay?
Basically, she can't.
Okay.
You may be seated.
I have to remember again, and I do delete everything after a year. Well, it doesn't really matter. It started to leave like my photos after a year and it's flipped out. Maybe to fix it, because I take photos of my kids. All right, I'll see you in a bit. All right.
Your Honor, calling people versus Jennifer Crumbley, case number 222799990, update.
Morning, John.
Good morning.
I have reviewed, the extraction provided by, I believe, the County Sheriff's Department and the sealed envelope to, the prosecutor. I reviewed all the text. I made a copy for Ms. Smith, and, Ms. Smith, do you have an objection to anything in the text chain?
No, I don't. I would ask that if the text chain is used, that it just be admitted as well.
Yeah, okay, so I am going to maintain a copy of the text chain in my own personal file, all right? And I'm handing a copy over to the prosecution,
Okay,
all right? So,
Thank you, Jessica.
can we continue the trial? What do you think?
absolutely.
Can we have just a minute to look at it?
Okay, yeah, it won't take you more than that, but yes. Okay, so could I have Ms. Crumbley to take the stand?
We just need a few minutes. We haven't seen them yet.
It sounds like you're going to. Just give me a second. I gave them to us. We didn't object. Now they get. But they're pretty short. So.
You're reading them, it should not take long. morning, even this evening. All right, so I know you think that we all went out to breakfast this morning. We did not, as I described for you in the beginning of the trial. Sometimes things come up. If you need to take care of legal issues, I usually try to do that while you're not waiting for us, but that's not always possible. So I appreciate your patience. And we are going to continue on cross-examination. All right, Ms. Crumbley, could you raise your hand? Do you swear or affirm the testimony you're about to give as a true self of God?
I do.
Right, you can put your hand down, and could you state your name again for the record, spell your first and last name?
My name is Jennifer Crumbley, Jennnifer Crumbley.
Go ahead, Pastor.
Thank you. Mrs. Crumbley, I'd like to talk to you about your vigilance as a parent. But before I do, I want to make sure that you understood the oath that you just took.
I do.
Okay, you understand that you took the stand under oath and you have to tell the truth?
I do.
You understand that was the rules yesterday as well?
Correct.
All right, we're going to come back to that. Now, you have been described by your attorney as a hyper-vigilant parent.
Correct.
Okay, do you agree with that?
I do.
In fact, you called yourself a helicopter parent before. Have family time together.
We did.
Now, I'd like to talk to you about what your digital footprint shows,
Okay.
what the evidence on your phone shows.
Okay.
Now, it's true, you agree with me that having horses is quite a time-consuming hobby,
It can be.
okay? It was for you,
It can be.
and that's what you said yesterday,
Yes.
okay? And you were at the barn for between 3 and 5 times a week,
More like 3 times a week.
3 times a week
Yeah.
for a couple hours a trip?
Correct.
Okay. It's also an expensive hobby.
It is.
So your banking records show that in the year of 2021, you spent over $20,000 on the horses. Is that correct?
Probably.
Okay. And that's not including cash. That's just from Capital One and Flagstar Bank.
Correct.
In fact, you told a coworker that half of your salary basically goes to the horses.
I might have. Yes.
Now, except on rare occasion, you didn't bring your son with you to the barn.
He was not into horses. I would ask every time I went to the barn, but he didn't want to go.
So the answer was no.
No.
Okay. And at least as far as your horses being boarded with Kira Pennick from June of 2021 to November of 2021, your son never went with you. Is that correct?
I think he went once when my in-laws were in town, and we met them at the barn.
Okay. But there was nothing stopping you from taking him.
No, he just didn't want to go.
Okay. It's a family atmosphere.
It can be.
Okay. Like the Halloween party that you had, that was for families.
Yeah, most of the kids there are young.
Okay. In the winters, you were on ski patrol as well.
Correct.
Okay. And that can be a bit of a time-consuming hobby.
It can be.
All right. And you would be on ski patrol between 1 and 2 times a week?
It's a total of 10 hours a week.
10 hours a week. Okay. So how many days?
I did doubles on Saturdays, so 1 day a week for me.
Okay. So you told this jury yesterday, you depicted your affair with Mr. Malash as a one time a week meetup at a Costco parking lot. Is that your testimony?
Correct.
Okay. But it wasn't just that, was it?
No.
Okay. In fact, there are numerous photographs sent to Mr. Malash.
Okay.
Yes or no?
I'm sure there was.
Okay. Numerous messages exchanged with him.
Correct.
And it wasn't just during the week, Monday through Friday, was it?
No.
No. In fact, that's what you said yesterday. But in fact, it included trips.
There were actual business trips that he met me on.
Okay. And included other individuals.
Yes.
What's Adult Friend Finder?
So we can go on and meet people who meet certain tastes that you're looking for.
This is 429. And you had the app Adult Friend Finder on your phone.
I do not believe I had the app. on my
Okay.
phone.
It was found on your phone.
Okay, well, I guess it was on my phone.
Okay. And there were messages from you to other individuals.
Correct.
Your Honor, I would object that this is going outside of the scope of the affair with Brian, but.
I don't think the court's ruling on opening the door was confined to just her extramarital affair with Brian Walsh.
Well, I guess, with regard to Mr. Wash, I determined that, the defense opened the door. I don't know that I determined that the defense opened the door as to other.
She depicted herself as having one extramarital affair for about a 6-month period of time, where she met with him one time a week. That was her testimony yesterday. We have evidence to the contrary, and I think it's important.
It's gonna get exciting.
All right,
It is what it is.
all right, well, go ahead, but
I won't delve too far
Okay, yeah,
into it, Judge.
really, this jury has been here a long time, and
I respect your time, Judge. I'll be brief.
You might have blushed.
So, Mrs. Crumbley, I'm sorry, this is not a laughing matter. Mrs. Crumbley, on Adult Friend Finder, we see messages from you in at least of August of 2021, August the 4th, 2021.
Okay,
Okay, and you don't dispute August the 10th of 2021,
no,
August the 11th of 2021.
no,
And more importantly, November 21st, 2021.
no,
Okay, and more important than that, November the 28th, 2021.
no,
Okay, you don't dispute that evidence was found on your phone.
I don't dispute it.
Okay, and you don't dispute that it wasn't just you and Mr. Malash meeting after work hours. It was with you and Mr. Malash arranging with other individuals to meet after work as well.
No, I only met with Brian during work hours. The times that we were at the hotel, I was on business. We did arrange for other people to meet us there.
So Sunday, November the 28th. You remember that day?
Mm,
It was the day after you took your son to the shooting range.
I don't remember it.
You don't remember that day?
No,
2 days before the high school attack?
no, I don't remember what I did that day.
Okay. Well, you were pretty specific in what you did on November the 27th with the firearm. You remember that,
Correct?
all right? Now, November the 28th, 2021, you spent your time arranging a meetup with somebody on Adult Friend Finder.
I never met anybody on Adult Friend Finder that day.
Arranging a meetup.
Oh, okay.
I'm not just talking about the time that you spent physically with somebody. I'm talking about the time that you spent and devoted your energy to setting that up.
Okay.
And you'll agree with me, it's not just the time period at the Costco parking lot or the time period at the hotel or the time period on the trip, correct?
That's the only time I met with people.
Right. But that's not the only time that you devote.
I guess I don't understand what you're asking.
Okay. Well, these meetups didn't just happen by themselves. You had to set them up.
Correct?
You weren't driven there. You weren't dropped off there. Time and your energy. Now, you told this jury that when your son texted you that he was seeing demons and bowls flying off the shelves, that was in the spring of 2021. You recall that evidence, right?
Correct.
You don't dispute that that was on your phone.
No.
You don't dispute that at some point you read those messages.
No.
And you don't dispute that your son said at least one time, "Can you please text me back?"
Correct.
You don't dispute that when you're at the barn, your other messages show that you can take pictures, send pictures, and receive pictures.
Usually I'm at the barn. If I take pictures and I try to send them, they don't go through right away, or I won't send them until I hit a spot where I actually have service.
So in Exhibit 423, the Facebook message chat between you and James, the chat that you deleted, there are a number of pictures that James sent to you from the barn of a horse in a conversation about that particular horse. Do you
Okay.
dispute that?
No,
Okay. And in fact, dozens and dozens of pictures of the lake.
I'm sure. Yes.
You're sure? Okay. And those pictures were sent to you with a timestamp on that Facebook message chat.
Okay.
Do you dispute that?
No.
No. Okay. And then you responded in that same time frame. Do you dispute that?
No.
No. So that conversation with that picture that was taken at the barn was occurring while one of you were at the barn.
I'm sure it was.
Okay. Now, you don't deny that your son wrote in his journal that he asked his parents for help. You don't deny that evidence that was admitted.
No, I don't.
Okay. And you don't deny that he wrote in his journal that he now had access to the 6-hour 9mm handgun.
I do not deny that.
And you don't deny that the 6-hour 9mm handgun was in fact the murder weapon.
I don't deny that.
And you also don't deny that that gun was gifted by you and your husband to your son on November 26th.
Describe gifted.
How about when you posted on Instagram his new Christmas gift?
Correct. And I explained yesterday that it was for him to use at the shooting range. We didn't just hand him a gun. as a here you go, son. It was something he could use when we went to the range as a family together.
You don't deny that in April of 2021, you described your son as being depressed.
I didn't describe him as being depressed. I noticed that he was acting
You
depressed.
used the word depressed.
Yes, he was acting sad. He was acting depressed.
Okay. And you know what depressed means?
It means a lot of different things.
Well, to you, it meant depressed, and you wrote that.
Right.
You don't deny in April of 2021, the evidence shows that your son told his only friend that he had asked you for help.
No, I deny that.
Okay. And you also don't deny that he told his only friend that you laughed at him.
I do not deny that.
Now, yesterday you told us that you took those messages in the spring of 2021, which, by the way, is at the same time you started your affair with Mr. Malash?
Around that time.
Okay. So in the spring of 2021, when you sent those messages, or when you received those messages, you indicated it was messing around.
It was.
It was messing around. In your mind, messing around. That's what your testimony was.
Yes.
Okay. Even when he said, can you please text me back?
I didn't see his text message, so I didn't text him back.
Even when your phone logs show missed calls?
Can you ask it again?
Even when your phone logs show missed calls from your son in that time period?
No.
Now, you said yesterday about these messing around texts. You agree with me that there's no indication in any text message, either between you and your son, or any Facebook message between you and your husband, in any of those exhibits, in fact, anywhere on your phone, that indicated that any of those messages were a joke.
No, there weren't.
There weren't. And we're talking about hundreds of messages between you and your son, and thousands of messages between you and your husband.
Correct.
And you don't deny that you never once took him to see a therapist or counselor.
No, I did not.
You did not. Testified that, actually Mr. Moss testified, that you would meet during work hours, and we've established that it wasn't just confined to work hours, but we're permitted to leave as you please.
Correct.
Okay. And your boss actually testified that no problem for you to time off.
Correct.
If you have a family issue, no problem, you can go.
Correct.
If you were sick, no problem, stay home.
Correct.
Okay. In fact, you could work from home on an as-needed basis.
Correct.
In fact, on November the 30th, you didn't even ask your boss if you could leave. You just told him you were leaving.
Correct.
And you told him when you were coming back.
Correct.
And you told him when you were coming back after receiving a phone call from the school asking for an immediate meeting.
Correct.
Because that was at, what, 10:05 a.m.?
Around that.
Okay. Now, had you ever been called, you have the TV on, please, Mr. Bloom. Had you ever been called?
Yeah, it takes some time for all three of them.
Sure, Doug. I have a few more questions I can ask before we get to these.
Okay, go ahead.
Have you ever been called to the school on an immediate basis before?
No,
Have you ever been told that your son had suicidal ideation before?
I was never told he had suicidal ideation before.
Okay, that's your testimony. But you've never been called to the school once for a meeting, I need to see you now,
No.
correct? Okay. So even before you had made it to the school, you had told your boss when you were coming back.
Correct.
So you had already put a limit on that meeting.
Not necessarily.
Well, you said, I'll be back in about an hour,
Okay.
right? That's your words.
About an hour.
Those were your words.
Correct.
This is Exhibit 74. Do you see it?
No, she doesn't.
Oh.
It's not on here. That's. Yeah, it takes a minute.
Okay. Yeah.
Can you see it?
Yeah.
Okay. This was sent to you. So Sean Hawkins called you at 9:24 in the morning, correct?
Correct.
Okay. You called him back at 9:27.
Correct.
You had a 5-minute phone call.
Correct.
And then in that phone call, he texted you the picture with it was drawn out. They emailed you this original picture.
Yeah, he texted me the modified one and then later emailed me this one.
Later is at 9:32.
Yeah, like after I asked him for it.
You looked at it.
I did.
Okay. You told us yesterday you found it I think your quote was a little concerning. What struck you about this?
Originally, when I saw the modified one, I was kind of angry at my son because we just talked about his missing assignments in geometry and his E the night before. Then when I got this one and opened it, it was concerning. I honestly thought the guy on there was a poor drawing of Batman, the way the thing in the cat. I thought it was a cape. I didn't know.
You thought that was a cape?
I did. I didn't look
Okay,
at
what
that
did you think
closely.
of the gun?
I thought it was a gun.
Yeah. What about the fact that it is identical to the gun that you got him for Christmas a couple days before?
I mean, honestly, it's just like it looks like a gun to me. I didn't even notice.
Well, you took a picture of the gun. You posted it on Instagram. You know what it looks like.
I do, but I didn't analyze it.
You saw Sergeant or Special Agent Brandon's testimony. He described how it's identical. And you told us yesterday how your son was a good drawer.
He's a very good drawer.
Okay. What about the thoughts won't stop, help me? Did that ring out to you?
Yes, that was what was concerning to me.
Blood everywhere, and there's a bullet. And actually, you were the one who bought the bullets in November the 27th.
Correct.
You later came to learn that those bullets were used in the shooting.
I did.
So you said yesterday it was a little concerning, yet you told your husband emergency in all caps.
Correct. That's why I left to go to school and I
you said-
texted him.
And he wrote back, "My God, WTF."
Correct.
And then you told him he was distraught about last night.
Correct.
Distraught's an intentional word you chose.
Correct.
Not sad. It's not a little anxious about school or his future. It's not talking about a video game. Distraught has a meaning.
Correct.
And you chose that word to send to him.
Correct.
So you went to that meeting, and this was November the 30th of 2021. And at that point, you'll agree with me that you knew prior to that day, the November 26th purchase day, that your son was wanting to get a 9mm. That's what you said yesterday.
Yes, I knew that they were talking about getting one because they had
Okay.
rented it in the past.
And you knew that he had shot one in the past.
Yeah.
Okay. And you knew that a 9mm is significantly more powerful than a 22.
I did not know that until I actually shot it.
Okay. Well, your dad took your son with James to the shooting range when they visited in July of 2021.
Correct.
And they talked about how powerful the 9mm was because they rented one.
Okay. I don't know.
Yes
if I
or
was,
no?
I don't know if I was part of that conversation, but if it was, it didn't register to me.
To register. Okay. You knew at the November 30th, 2021 date that your son's friend had been taken without notice to your son.
Correct.
You said, I'm sorry, incorrect or
I said correct.
Correct. And you knew that when your son's friend was taken, your son was extremely upset.
He was upset. Yes.
He didn't go to school for a few days.
I don't remember that.
Okay. Well, if the school records show that he was absent for a few days after that, would you deny that?
I wouldn't.
And would you deny that he missed school because he was so upset?
I don't know if he missed school because he was so upset or maybe he was sick. I don't know.
Now, you told us yesterday and you acknowledged that that individual, that child, was like a second son to you.
Correct.
So he was the only one that your son hung out with.
Outside of school. Correct.
Okay. Well, who did he hang out with inside of school?
He named some names to me. I've never met them before, but he told me some group of kids that he sits and eats lunch with and he talks to in class.
Did he ever visit their houses?
No.
Did they ever visit your house?
No.
The only other peer to visit your house was this student who left the state around Halloween 2021.
At that time. Correct.
We're talking about that time in October, in September, in at least August, July, June, May, all
Of
2021.
2021. Correct.
2021, thank you. Now, he left on Halloween, and you knew that your son was planning to hang out with him on Halloween,
Yes.
okay? But his friend didn't show.
I had texted his friend's mom the day before trying to confirm if he was still coming over. And that's when we found out that he was driven to Wisconsin and taken to that school.
Okay, so you're telling us you found out the day before Halloween.
Yeah.
Okay. So that didn't stop you and James from going to a Halloween party at the barn.
I don't believe it was on Halloween.
Oh, that's what Kira testified
It was
to.
it was the Friday before Halloween.
If there was a picture with a date stamp on it, would you deny it?
No.
Okay. And it didn't stop you from after you left that party without your son. You went to another Halloween party.
We did.
And your son was home alone at that point.
Yes.
So you talked to us a little bit about your son's hobbies in 2021. But in November of 2021, so we'll start with November the 1st, 2021. You know that those hobbies were non-existent. And I'll go one by one.
Okay,
So you told us about bowling.
correct.
Bowling the team wasn't in session at that point in time, was it?
No, I think actually at that time he decided he didn't want to do bowling that year.
Okay, so he stopped bowling the
He did.
sophomore year.
He did.
And it wouldn't have been bowling season anyway.
I guess not. No.
So one hobby you talked about yesterday, that was not in existence in November 2021.
Correct, but we did still go to the bowling alley with him.
And you said that he worked, but would you be surprised to learn that he only worked a few shifts post-COVID?
No surprise at all.
So he wasn't at work every day.
No, he worked Tuesdays and Thursdays and sometimes Saturday mornings.
Okay. But not very often.
No, not very often.
A handful of shifts post-COVID, which of course, March 2020 is when things shut down.
He was working on a weekly basis.
And you knew that he didn't have any friends.
That's not the right way to put it. I knew he had friends, but no, he did not have many
You
friends.
had never met another peer his age who he referred to as a friend.
He actually had friends that used to come over prior to 2021 that he was still in contact
We
with.
went through defense exhibits yesterday from 2019 to 2020. I'm talking about 2021, at least from the time period where he sent you a message that he saw demons in the house.
Right. In 2021, the only friend that came to our house was the one that was
Right.
on the thing.
So you knew to be true in November of 2021 that he had no peer support.
I don't know what he had in school. He told me he had friends in school that he talks to.
Okay. You never met him
No,
though. Okay. And he didn't have any clubs at school he was a part of.
no, not that year.
So you told us yesterday that your son wanted to design video games.
Correct.
Okay. He wasn't in a robotics club or a coding club at the high school.
He did take a coding class prior to 2021, and he was in a robotics after school activity in middle school.
Talking about in
I'm just telling
2021.
you, he's been in that before.
Now, despite what you have called yourself as a vigilant parent and a helicopter mom, you never decided in at least November of 2021 to look at his phone.
No,
That's despite what happened in the spring of 2021, right?
what happened in the spring of 2021 did not concern me.
Okay. Now, the one thing that seemed consistent with your son, to you at least, is his desire to obtain a weapon. Is that right?
I wouldn't say that, no.
He had a consistent desire to obtain a weapon.
Not to me, he did not.
Okay. You didn't know about the 9mm?
Oh, I knew about it.
Okay. You didn't know about the 22s?
I knew about them.
And in fact, you posted on Instagram that he got himself a 22
Correct.
in June of 2021.
Correct.
And from that time up until the November 26, 21 purchase, he was wanting to get a 9mm.
I know him and my husband had discussed getting a 9mm. I'm not part of those conversations.
But you knew about it.
I knew, but not that he was so, however you described it.
I said he consistently had a desire to obtain a weapon.
I know they consistently talked about it. Correct.
Okay. They didn't just talk about this is a gun. He talked about how he wanted the gun. You don't deny that.
Oh, no.
In November 26, you said you weren't there for the gun purchase.
No, it's not.
Okay. But are you telling us you didn't know it was going to happen?
I did not know they were going to the gun store that day. No.
Okay. But you knew that you were going to eventually get him a 9mm.
No, I did not know that.
Okay. So you're telling us that that was a surprise purchase to you?
It was a surprise to me that they went to the gun store that day.
Okay.
It was not surprising to me that they purchased a gun that day.
And it didn't upset you that it bought a gun?
No, it did not.
It upset you that it cut into your Christmas tree shopping time, but it didn't upset you that it bought a gun?
Correct.
And you told us that it was, in your words, James's responsibility to take care of that gun.
Correct.
Now, you don't deny that, at least according to the cell phone evidence, the photographic and video evidence, you're the last adult to have possession of that gun.
Correct.
You were with him at the range on November the 27th.
Correct.
You saw your son shoot the weapon.
Correct.
You saw him shoot the last practice round before the shooting on November 30th.
At the range?
Yeah.
Yes, correct.
You saw how he stood.
Honestly, that didn't mean anything to me at that time until this whole case came about and I've learned what a shooter's stance is. So
He knew how to use the gun.
yes, he did.
Okay.
He's used one before.
In fact, he showed you how to use the gun.
Correct.
Okay. And the stance he took, you saw from the Oxford High School video, was the same. You saw that, right?
I don't know. I can't compare it. I don't know.
But you entrusted this responsibility. Will you agree with me that owning a firearm involves a great deal of responsibility and trust?
I do.
And you entrusted this responsibility to your husband, James.
I did.
If you look at Exhibit 423, that's the Facebook chat thread between you and your husband. It's pretty clear you didn't trust James with much. Would you agree or disagree?
Depends on what you're talking about.
Okay. Well, you didn't trust him to get out of bed on time.
Correct.
You didn't trust him to cut the grass when it was time to cut the grass.
He would cut the grass when it got to a length I didn't like. I didn't trust him.
You didn't trust him to update you on his whereabouts.
There's a reason behind that.
You didn't trust him to not turn off or turn on the Ring camera in your home.
Correct.
You didn't trust him to keep track of your son.
Oh, I trusted him to check my son.
In those messages that we'll see in Exhibit 423, asking him, where is your son, over and over and over again, does that signify trust or distrust to you?
That was when my son was walking home from school. Not that I did not trust my husband with my son.
Okay. And you didn't really trust your husband to hold down a job.
It's not that I didn't trust him to hold down a job. He had a hard time holding down one after COVID.
Okay. And in those messages, you are